want to start the sitting now. Registrar, call the case.
Thank you, my lord. Resumed today, virtually before His Lordship, Honorable Justice Sanusi Kado presiding. Suit number NIPN YL 11 2018 between Yakubu Jeremy and Aki Computers Limited and another. My lord, the parties are absent.
The claimant is not online. Is the claimant present?
My lord is not present. The parties are absent.
Appearance. Appearance.
With respect, announcement for the defendant. My name is GC Adiku.
Sit down, and don't stand off. Sit down and make your submissions. Yes, your name is
GC Adiku, my lord.
GC Adi.
GC Adiku, my lord. Adiku, ADIKW.
Adiku.
Yes, my lord. I most respectfully appear with my colleague FJ Akau.
With who?
With FJ Akau.
FJ Akau.
Yes, Akau is AKAU Akau.
Yes.
Thank you, my lord.
Any other appearance?
No,
appearance for the. Are you appearing for who?
I'm appearing for the defendant, my lord.
Okay.
Defendant counterclaimant.
No appearance for the claimant.
Yes, my lord.
Yes, this matter is for judgment. The judgment of the court is ready. I shall start by indicating that on 25th day of February 2021, when the parties adopted their final written addresses, the court adjourned the matter to 20th day of May 2021 for judgment. However, the JUSUN strike set in and disrupted court sitting. That's why the judgment could not be delivered as scheduled. That's why it is being delivered today. The claimant in this suit took out a general form of complaint on the 19th day of November 2018. The complaint was accompanied by statement of facts, list of witnesses, list and photocopies of documents to be relied on at the trial. The claimant sought for the reliefs as per his statement of claim, as per his statement of facts. I have reproduced the reliefs being sought by the claimant, so I will skip reading them. Counsel will have them when they get the hard copy of the judgment. Upon being served with the originating court process, the defendants, in reaction to the originating court process, filed their joint statement of defense, wherein they incorporated a counterclaim. The claimants testified for himself in the proof of his case and tendered document and evidence, which were admitted and marked as exhibit accordingly. The defendants on their part called 5 witnesses, including the second defendant who testified in the defense of the defendants. Documents were also tendered by the defendant and they were accordingly admitted and marked as exhibit. I have, in the body of the judgment, reproduced the facts leading to the institution of this case, so I will skip that aspect. I go to the submissions of the counsel for the defendant counterclaimants. The defendant's counterclaimants formulated 2 issues for determination. The issues are: 1, whether the claimant complied with the terms of Exhibit A and is entitled to settlement as contemplated by Exhibit A Apprenticeship Agreement. 2, the second issue is whether the defendants have proved their counterclaim and are entitled to judgment. The argument of counsel on the 2 issues have been captured in the body of the judgment, so I will skip that aspect also. Then I go to the submissions of the claimant, who is defendant to the counterclaim. The claimant also formulated 2 issues for determination, wherein the first issue is whether, as per the pleadings and evidence adduced, the claimant is not entitled to relief sought before the Honorable Court. The second issue is whether there is a competent counterclaim filed by the defendant before the Honorable Court for consideration. If the above is answered in the affirmative, then the next question to be answered is whether the defendant counterclaimants have, as per their pleadings and evidence adduced, prove their counterclaim. The argument of counsel for the claimant on the issues submitted to the court for resolution have been captured in the body of the judgment, so I will skip that aspect also.
Please.
The parties also file written addresses on jurisdiction of the court. The argument in that respect has also been captured in the body of the judgment. I now go straight to the decision of the court. I have carefully and painstakingly perused the originating process commencing this suit, the statement of defense in which the defendants incorporated their counterclaim. I have equally considered the defendant's reply to the defense to the counterclaim, the written addresses of counsel, as well as the oral submissions in adumbrration to the position of the respective client, to the position taken by the respective clients of the counsel. It behoves of me to first and foremost resolve the issue of jurisdiction of the court to entertain this issue as it is presently constituted. The counsel for both parties have, in June 2019, in the course of the trial, filed addresses on issue of jurisdiction of the court to entertain this suit. The argument was postponed till final addresses. Counsel for the defendants has also, in addition to the addresses on jurisdiction, went ahead to file a separate notice of preliminary objection dated 23rd. The divergent views on the issue of jurisdiction of the court on this issue. For the claimant, the contract before the court for enforcement, which is Exhibit A, is a contract of service, while the counsel for the defendant has taken the view that the contract before the court Exhibit A, which is the foundation of this suit, is a contract for service to which this court lacks jurisdiction to entertain. In arguing the issue of jurisdiction, counsel for the claimant is of the view that the case borders on contract of service or that of contract and not that of contract for service. According to counsel for the claimant suit borders on contract of service, which this court is amply empowered by Section 254, subsection 1 of the 1999 Constitution as amended, with the jurisdiction to entertain. Counsel further supported his position with the pleadings of the defendants in paragraphs 2, 3, 4, and 5, where the defendant stated that the contract between the claimant and the defendant is that of service. Counsel also relied heavily on the case of Shena Securities Limited versus Afrofac Nigeria Limited. The defendants on their part, despite stating in their pleadings that the contract between the claimant and the defendants is a contract of service, argued that the contract in Exhibit A between the claimant and the defendant is contract for service, which this court lacked requisite jurisdiction to entertain. Counsel placed reliance on the case of Shena Securities Limited versus Afrofac Nigeria Limited. The parties are agreed that Shena Securities versus Afrofac Nigeria Limited (SUFRA) had laid down the test for determining whether a contract is that of contract of service or contract for service. I have read the case. I agree with counsel that the Supreme Court decision in Shena Securities Limited (SUFRA) has clearly provided guidelines for determining the nature of contract in case of a dispute. However, the criteria stated in Shena Securities (SUFRA) are not exhaustive, as there are other criteria that the court considers when faced with the task of determining whether a given contract is that of contract of service or contract for service. I have examined Exhibit A, the agreement of the parties, which is the basis of this case. It is clear to me after a thorough examination of Exhibit A, vis-a-vis the decision in the case of Shena Security Limited versus Afrofac, that the agreement between the parties in this suit is not that of contract of service. Likewise, it is not contract for service. Rather, it is a contract of apprenticeship. This is apparent when one takes into consideration the fact that the agreement has not made any provision for payment of fixed or agreed amount as salary for the claimant for the services to be rendered to the defendant. Therefore, the absence of lack of payment of salary to the claimant has taken the contract out of contract of service, the purview of contract of service. Likewise, the agreement of the parties as depicted in Exhibit A cannot be said to be that for contract of service, for the simple reason that the claimant is not an independent contractor, rendering service to the defendant independently without supervision or taking directives from the defendant as to how the terms of the contract should be executed. It is clear from Exhibit A, that the claimant The claimant's job requires taking instruction from the defendant. Which is contrary to the position that he is an independent contractor. The mere fact that the defendant or claimant in their respective pleadings have described the agreement to be that of contract of service or that of contract for service does not ipso facto makes or renders such a contract to be so. It is the substance of the agreement that is material when it comes to the determination of whether a contract is that of service or is for entirely another thing. For all intent and purposes, as can be gleaned from the agreement of the parties, as contained in Exhibit A, the agreement of the parties is a contract of apprenticeship, which this court, by virtue of Section 254C1, has the requisite jurisdiction to determine. It has the exclusive jurisdiction to entertain. I find so and hold. It is pertinent to note the contract of apprenticeship is well recognized worldwide, and in Nigeria, it has been recognized statutorily and by custom. There are several statutes that contain provisions for apprenticeships, such as Labor Act, Employee Compensation Act, and Industrial Training Funds Act, to mention a few. In Nigeria, among the various ethnic groups, the customary apprenticeship has been institutionalized. It has been institutionalized as it has been in practice for a very long time prior to colonialization of the entire entity now called Nigeria. The practice of customary apprenticeship is more pronounced among the Igbo's ethnic group. See Elizabeth A. Oji and Ofonze D. Amuchiazi on Employment and Labor Law in Nigeria, published by Invei and Associate Nigeria Limited, Lagos, 2015, pages 39 to 60. The International Labour Organization has, in International Labour Recommendations number 60 of 1939, 25th section, June 8 to 28, 1939, held at Geneva, defined contract of apprenticeship as follows. Any system by which an employer undertakes by contract to employ a young person and train him or have him trained systematically for a trade for a period, the duration of which he has fixed in advance and in the course of which the apprentice is bound to work in the employer's service. The Labor Act also has similar provisions on apprenticeship. Under the Labor Act, there are two categories of apprenticeships. see Section 49 of the Labor Act. Although there is no indication in the agreement as to the age of the claimant in this suit to indicate which category he belongs. However, from my observation and by appearance of the claimant when he had testified before the court, the contract falls within the second category. That is to say, it involves persons of 16 years of age and above. The labor law also fixed the maximum length or duration of contract of apprenticeship to be 5 years without any possibility for a renewal or extension. It is clear from the foregoing that a contract of apprenticeship is recognized as constituting a special category of contract of employment due to its peculiarities and specific formalities usually required for it. That's why scholars have given it a special treatment. Section 50 of the Labor Act provides that every contract of apprenticeship shall be in writing, attested to and made with the approval of the authorized labor officer. Before attestation any contract of apprenticeship, the labor officer is to be satisfied that the apprentice has consented to the contract freely without coercion or undue influence or as a result of misrepresentation or mistakes. It is clear from the content of the provisions of Section 50 of the Labor Act that a contract but a contract of apprenticeship must be adduced in writing. In the case at hand, Exhibit A clearly shows that it is a contract of apprenticeship that was reduced into writing by the counsel for the defendant. However, it is noticed from content of Exhibit A that there was nowhere the agreement of the parties, the apprenticeship agreement was attested by an authorized labor officer. The failure or neglect by the parties, more particularly the first defendant, whose lawyer prepared the said agreement, cannot, in the circumstances of this case, render the apprenticeship agreement impossible. The reason being that the defendant has, by refusing or neglecting to present the apprenticeship agreement Exhibit A, breached the clear provisions of Section 50, subsection 3 of the Labor Act. The breach was more pronounced considering the fact that the apprenticeship agreement Exhibit A was prepared by the defendant's counsel. Therefore, the failure to present the apprenticeship agreement to the authorized labor officer for attestation, and the continuance of the agreement 6 months beyond the date of the execution has made the defendant liable has clearly shown that the defendants are in breach of the clear provisions of the law, because the defendants have engaged an apprentice, that is the claimant in this case, for a period of 5 years without attestation of the agreement by the authorized labor officer. The defendants' failure to ensure law, therefore, they will to benefit from their own wrong. They will not be allowed to influence the agreement which they had entered. They had entered their eyes wide open with the claimant. The reason being that the action of the defendant is not having an authorized officer to attest to the apprenticeship agreement was clearly deliberate, as counsel was involved in preparation of the agreement. Furthermore, the National Industrial Court of Nigeria, like every other labor court, has a duty to ensure parties ventilating their grievances are treated fairly, and none of the parties is allowed to take advantage of the other due to his disadvantaged position or vulnerability, like in the case at hand, where claimant is at disadvantage, where the claimant is at disadvantaged position compared to the defendant. To support this view, I shall refer to the Supreme Court, to the Indian Supreme Court decision in the case of NTF Mills Limited versus the Second Punjab Tribunal, reported in 1957 SC 329, where the court stated thus: in the course of adjudication to determine the right and wrongs between employees and their workers, the court's jurisdiction is invoked not for enforcement of mere contractual rights, but preventing labor practices regarded as unfair and for restoring industrial peace. It is also pertinent to note that this court is not only court of law, but also court of equity. In the task of adjudication, this court is required to assuage the hardship of the law by applying equitable doctrines in doing justice between parties. See also Section 15 of the National Industrial Court Act 2006. It is also one of the cardinal principles of interpretation to consider statutory provision holistically so as to arrive at interpretation that will not do violence to the law and bring out clear intention of the lawmakers. Therefore, in interpreting statutory or constitutional provisions, court of law is enjoined to give the provisions their plain meaning, thereby using literal interpretation, except where it will lead to absurdity. In any event, court is duly bound to interpret statutory or constitutional provision by construing the entire provision holistically in interpreting them to accord with the intention of the lawmakers. See the case of Ladoja versus INEC. See also Okogi versus AG Lagos State. See Garba by FCSC. See PDP versus INEC. See also Golom versus Obasanjo and other cases cited therein. It is clear from the above quoted decisions of the Appellate Court that the interpretation of provisions of the law must be interpreted holistically, taking into consideration all relevant sections of the law in the context of the provisions. Any interpretations that disregard or jettison the context in which the provisions are used in the statute or construed will do violence to the provision. In applying the holistic approach to ascertaining the correct meaning of the provisions of Section 50 of the Labor Act, it is clear to me that the said provision could not avail a party who deliberately refused to carry out the letters of the law and decide to do the contrary. She should not be allowed to benefit from the wrong attitude to the law. The defendants, having failed to carry out the letters of the law by deliberately refusing or neglecting to present Exhibit A to authorize labor officer for attestation, cannot benefit from their own fault by having the agreement not to be enforced. to allow the defendant take advantage of their own wrong will amount to treating the claimants unfairly after having been made to fulfill his own side of the undertaking. Such an advantage will amount to unfair labor practice. In view of the foregoing, I hold that the agreement between the parties in this case is that of contract of apprenticeships, and it is enforceable by this court, as he who comes to equity must also do equity. I shall now turn to the merit of the claim of the claimant's case before the court. It is clear from the pleadings and evidence that the thrust of the claimant's claim is that the defendant, by Exhibit A, engaged him to serve as an apprentice for a period of 5 years, from 25th day of September 2011 to 24th day of September 2016. There is no disputing the fact that the claimant has served the terms of apprenticeship for 5 years. However, the defendant have failed and refused to settle him by renting a shop for him for a period of 1 year and stocking the said shop with goods. The reason given by the defendant for not carrying out the letters of the agreement Exhibit A is that the claimant has breached the agreement by helping himself during the period of apprenticeship. The law regarding proof is that it is the claimant who claims that must prove, and the labor relation and employee can only claim if he shows an entitlement. An entitlement is shown by reference to the law or that gives it, or the condition of service governing the relationships of employee and employer. In the case at hand, the relationship is governed by Exhibit A. In the case of Gabriel Atibi versus Kabel Mantel Nigeria Limited, reported in 2008 LPLR 591 SC, the Supreme Court has stated that a claim is circumscribed by the relief's claim, and the duty of claimant, therefore, is to plead only those facts and materials as are necessary to sustain the reliefs and adduce evidence to prove them. Now, a look at the reliefs claimed by the claimant will show that they are hinged on Exhibit A, the apprenticeship agreement. The main or principal reliefs being sought by the claimant as per the statement of fact is an order of this court compelling the defendant to honor the agreement freely entered into with the defendant on the 25th day of September 2011, requiring the defendant to serve the defendant for a period of 5 years, thereafter to settle the claimant by renting a shop and paying 1 year rent in advance, as well as stocking the shop with goods upon completion of the agreement, and with the agreement coming to an end on 24th day of September 2015. There is no any other agreement that is still subsisting. The claimant is claiming that he has fulfilled his own part of the obligation by serving the claimant for 5 years and even adding extra 15 years. There is also an alternative reliefs being sought by the claimant. There are also claim for gain on the claim on gain for the period that the claimant is supposed to be settled. There is also the general damages and also the cost of engaging solicitors and the cost of the suit. The claimant, in proof of his case, relied heavily on Exhibit A and the testimony of DW1, and that under cross-examination, and that of DW5. From the evidence before me, the parties in this suit have agreed that the claimant has served for 5 years as per Exhibit A. In fact, he was made to serve extra 15 months. This means that the claimant has fulfilled the task assigned to him by Exhibit A and has done all that is required of him to do. The defendant who now refuse to carry out their own part of the bargain are asserting that the claimant has breached the terms of agreement in Exhibit A. Therefore, the defendants are, by the positions they have taken, have the onus of proving their assertion. See Section 134 of the Evidence Act. The law as regard burden of proof is well settled, that a claimant is saddled with the initial burden of proving his claim. After discharge of initial burden, the ownership to the defendants to prove their assertion. In disputing the case of the claimant, the defendants, in proof of their position, stated that the claimant breached the terms of Exhibit A, the agreement which governs the relationship of the parties. According to the evidence of DW1, under cross-examination, the claimant breached the undertaking to open shop from 7:30 a.m. to 6 p.m. DW1 gave the dates of 26th day of March 2016, 30th day of June 2016, 2nd day of March 2017, and the 5th day of August 2017 as days which did not fall within public holidays, but the claimant without justification closed shop. In proof, defendants relied on Exhibit DW1, DW1A, and DW1B, the daily sales books of the defendant. The claimant failed to open as proof of defendant failure to open the shop as agreed. A response counsel for the claimant submitted that from daily sales books, Exhibit DWA and Exhibit DW1B, the claimant has complied with Exhibit A as the evidence before the court revealed the opposite. I have perused Exhibit DWA and Exhibit DWB sales books. It is clear to me from this exhibit that on the 25th day of March 2016 is a Saturday and it falls within the Easter break. In the circumstances, the claimant cannot be faulted for not opening shop on that day. For the 30th day of June 2016, the record in Exhibit DWA clearly shows that sales were made on 30th day of June 2016. This means that the shop was opened on 30th day of June 2016, because if it was not open, there would have been no sales indicated in the sales book. This has debunked the claim of the defendant on the claimant not opening shop on that day. For the remaining days, they all fall outside the duration of Exhibit A. In the circumstances, they cannot be of any help to the defendant, even if it is proved that the claimant has not opened shop on those dates, because the dates did not fall within the time when Exhibit A was still in operation. The defendants have also submitted, while placing reliance on Exhibit DWA and Exhibit DWB, that the value of goods sold using the defendant invoices are not recorded in the sales books Exhibit DW1A and Exhibit DWB amount to the tune of 2,459,000. 5,805 meters. It was endorsed on the collected or received, which means the transactions were aborted, not completed. According to council, it is only completed transactions that are recorded in sales books. Council also argued that there was no evidence that these items were supplied. On Great King's invoice number 00954, exhibit DW1G, the position was explained in exhibit 10 to N to F of the claimant's additional evidence before the court. And this was never contradicted. The defendants had have in paragraphs 12H admitted knowledge of the said transaction. I have noted that from exhibit DWG to DG66, the invoices were not issued by one person, as the signature of the issuer of some of the invoices differs with the signature of the issuer on some other invoices. The claimant also stated that he is not the only person in the shop. There are other employees of the defendant that sold items in the shop to customers. There is also evidence to the effect that DW1, who is the second defendant in this case, has also been selling goods from the shop in the absence of the claimant, which he has not denied, as he has extra key of the shop. This evidence was never disputed by the defendant. In fact, the second defendant in his evidence before the court has confirmed so, as he claimed that it is his shop, he has the right to supervise. In the circumstances and in the absence of evidence to show that the items which were shown on exhibit G to G66 were actually supplied or received by the claimant, the claimant cannot be blamed for such, more particularly when it is shown that the exhibit were not issued by the same person, and there are other persons that sell in the said shop. In the circumstances, I accept the explanation given by the claimant on the invoices and not recording them in the sales books, as the said transactions were either not completed or are cancelled. On the opening of account by the claimant with Fidelity Bank, I have not seen any clause in the agreement exhibit A which barred the claimant from having an account during the period he is to serve the defendant. Furthermore, the transaction in the accounts which were the subject of this complaint by the defendants are not within the operations of exhibit A. They are transactions that took place after the expiration of exhibit A. After the lapse of exhibit A. in the circumstances, the opening of account cannot be a breach of Exhibit A. On loss or unaccounted goods, item missing, an item over exhibit, and items over, which as in Exhibit DW1I, it is submitted that the claimant breached Exhibit A by failing to account for all goods received and goods sold. On this, counsel refers to Exhibit DW1I, stock report of 21st day of October 2015, and that of 12th day of February 2017, which was admitted as Exhibit DW1J, which shows value of good missing amounting to the sum of 1,368,100 naira. Counsel for the defendant insisted that because of the missing stock, claimant is not entitled to settlement as per Exhibit A. It was also submitted Exhibit DW1K is as a result of disagreement with the accuracy of Exhibit DW1I, e.g. stock taken by the second defendant. By Exhibit DW1K, items were still missing to the tune of 225,195 naira, which is the report of the claimant himself. Counsel submitted, even if Exhibit DW1J was inaccurate, Exhibit DW1K has shown claimant was not honest, diligent, and painstaking in handling all that he was entrusted with. The claimant's answer to missing stock is that he cannot be responsible as there were other staff working in the shop. Furthermore, the second defendant has keys of the shop and accessing same even after closing hours, mostly at night. The second defendant has also admitted selling goods when claimant was not in office. It is submitted by counsel that with the stock over minus stocks received will show that the defendant never suffered any total over any loss, did not suffer any loss or shortage. No goods of the defendant got lost as alleged by the defendant. The defendant have made a lot of noise, but missing items or unaccounted items as what made the claimant not to be entitled to settlement as per Exhibit A. I have perused the exhibits which the defendants heavily rely in proof of the allegations that items were missing and that court should hold the claimant responsible and hold that the claimant, by not accounting for the missing items, is not entitled to be settled by the defendant for the 5 years he has served as apprentice with the defendant. Exhibit DWJ, stock report of 21st day of October 2015 to 12th day of December 2017. This document has no evidential value due to the fact that it has been altered. This exhibit has been altered with blue and red biros. There are several question marks with red biros which have not been explained why such question marks were made on the document. There are also notices. I have also noticed marks as star and ticks and XX signs with blue biro and red biros on the document. It is not that all the alterations were not discontinued. It is noted that all the alterations were not authenticated by any person who altered by the person who altered the said document. In the circumstances, I discountenance Exhibit DW1J for not having evidential value due to alterations at occurs. Due to unexplained alteration. For Exhibit DW1K, this is a photocopy with a blue biro writing on top, stating item missing and items over. This document is defective in the sense that it was a document that has unknown author. It is a document that was never signed by anybody or person. The absence of signature and author has rendered this document valueless. It is not more than a worthless paper, a piece of paper. This document being a document that was not signed and has no author, has no evidential value in the face of the law. This document, in the circumstances, is hereby discountenanced for the purposes of this judgment. See the case of Fashewun and others versus Attorney General of the Federation, reported in 2006 LPLR 5567 CA. See also the case of Brewtech Nigeria Limited versus Akin Nowo and another, where it was held that an unsigned document is worthless and void, as a worthless and void having no evidential value. I therefore found and hold that the Exhibit DW1K is a worthless document, has no evidential value for not having been signed by anybody or person. Then Exhibit DW1H and DW1I also suffered the same fate with Exhibit DW1K, as they are documents that have no author and they are unsigned. They are hereby also discountenanced for the purpose of this judgment on the same reason why Exhibit DW1K was discountenanced by this court. Having found Exhibit DWJ, DW1K, DW1H, and DW1I not having any evidential value, the claim of the defendant that the items were missing and the claimant should not be made, and the claimant should be made to pay for it has not been established. Has not been established. The defendant has not discharged the burden of proof on him on this assertion. On the whole, I found the defense of the defendant not to have been proved. The evidence before me clearly shows that the claimant has served the defendant for 5 years as an apprentice, and he is entitled to be settled as agreed in Exhibit A by the defendant by renting a shop for him for a period of 1 year and paying the rent, as well as stocking as well as stocking the the refusal of the defendant to settle the claimant on ground that he helped himself was an afterthought, as it was not during the period of the agreement that this that the defendant's refusal to settle the claimant on the ground that the claimant helped himself is clearly an afterthought, as this was done was after the elapse of Exhibit A, which governed the agreement. The claimant having performed his own part of the bargain as per Exhibit A, and the terms of the agreement having elapsed on the 24th day of September 2016, the defendant is stopped from claiming that the defendant has helped himself and is not entitled to any settlement as per the agreement. The defendant is bound to observe the terms of the agreement as contained in Exhibit A. The agreements contained in Exhibit A were the conditions that bound both parties, as it was an agreement between the parties to which they were not forced to agree on. I so find and hold. The alternative prayer of the claimant cannot be considered having granted the main or the principal prayer, as the law is that where the main prayer or principal prayer is granted, the alternative prayer shall not be considered by the court. On claim for gain per annum, there is no evidence before me that the claimant will ever gain the said amount as said, as no, the court has not been informed of the quantity of the goods which were to be stocked, the quantity of the good to be stocked for the claimant, which would have made him to gain 300,000 naira per annum. That relief fell and is hereby refused. On the claim for damages, these two cannot be granted upon the grant of the main claim of the claimant. Likewise, the claim for payment of 50,000 naira per month for the period of 15 months has not been proved by any cogent evidence. The claimant has not adduced evidence to establish that he would be entitled to 50,000 per month. In the absence of such evidence, the relief fails and is hereby refused also. On payment of solicitor's fees, it has not been shown that there is any agreement between the defendants and the claimant that the defendant shall shoulder the responsibility of payment of counsel engaged by the claimant. In the circumstances, the claim for solicitor's fees fail and same is hereby refused. I now turn to the second issue for determination, which is on first and second defendant's counterclaim, which was contained in paragraph 51 of the joint statement of defense of the defendant. I have reproduced the counterclaim in the body of the judgment, so I will skip reading the counterclaim. The relief being sought in the counterclaim are 8 in numbers. It is settled law that a counterclaim is a cross action with separate pleadings, judgment, and cost, and not merely a defense to the claim before the court. It is an independent action that is not part of the original action, although for convenience they are tried together. In such trial, parties in the original action swap places or positions. The defendant assumes the position of the claimant, while the claimant assumes the role of the defendant. Thus, a counterclaim is a weapon of defense that allows the defendant to impose a claim against the claimant as effectually as an independent action. But a counterclaim cannot be inconsistent with the claimant's claim in the sense that it cannot erect a totally different case from that of the claimant. See the case of Okonkwo versus CCB Nigeria Limited. A counterclaim, being a separate and independent claim by itself, can only succeed by discharging burden of proof like the onus a claimant has in proof of his case by strength of his case by adducing cogent and compelling evidence. The law remains that he who asserts or claim or a relief must prove by credible, admissible evidence. The burden is on the counterclaimant to prove his counterclaim. See the case of Suffolk Pet Services Limited versus Adnan Mansour Nigeria Limited, reported in 2019, 2 Nigerian Code Report, Part 1655, page 1. The claimant in the case at hand is contesting the competency of the defendant's counterclaim. It is also contended that the defendants have not proved their counterclaim. The counsel for the claimant, a reliance on the case of Okonkwo versus CCB Nigeria Limited, submitted that the defendants' failure to heed their claim, counterclaimant, has rendered same invalid. According to counsel, being conscious of incompetency of the claimant's claim, that's why the claimant only filed a reply to the defendant's joint statement of defense without defense to counterclaim, as there is none before the court. Despite the non-filing of the defense to counterclaim, the defendant filed defendant's reply to claimant's response to counterclaim together with additional witnesses' statement on oath and other document. It is submitted that the defendant's reply to the claimant response to counterclaim together with additional witness statement on oath and other documents filed are all incompetent and should be discountenanced. The defendants, in reply to the objection of the claimants to competency of the counterclaim, submitted that the case relied on by the claimant is not on all fours with the case at hand. Counsel argued that the said case is not applicable to the case at hand. I have thoroughly studied the statement of defense of the defendant, wherein they incorporated their claims in paragraph counterclaim in paragraph 51 of the statement of defense. It is clear to me that the facts relied by the defendant in their defense and the counterclaim are same. The law permits using the same evidence in defense and in proof of counterclaim. A counterclaim will not be defeated for not having been separate paragraphs of pleading, Christine as counterclaim or pleading to counterclaim. What is important is the substance of the facts to be relied on. It is right that a counterclaim may arise from the same transaction as in the main action and can be and for convenience be determined together for the same set of facts and circumstances, in which event the main claim and the counterclaims are heard together, with each respective party in the reverse role leading evidence in proof in proof or in defense of the claim. The parties having joined issues on their pleadings, see the cases of Oroja versus Adeni. See the case of Oroja versus Adeni, 2017, 16 NWLR 1560, page 138. The evidence adduced before the trial, before me, in respect of the main claim, is same evidence used in resolution used by the defendant in proof of their counter claim. The evidence adduced in the main claim is not separate from the evidence in the counter claim. They compartmentalize into they need not to be compartmentalized into evidence for the main claim and evidence for the counter claim. See the case of Think Ventures Limited versus Spice and Regular Limited, reported in 2021 to Nigerian Ukulolo Report, part 1759, where the facts relied on are same. It makes no sense. It makes no sense to compartmentalize them as defense and counterclaim. This means where facts pleaded in the statement of defense are the same as those to be used for the counterclaim, it does not make sense to repeat them as pleading for counterclaim, especially where the two are joined together as in this case. The statement of defense counterclaim, a defendant is allowed to adopt his pleading in his statement of defense for his counterclaim. Where that is done, the claimant cannot be heard to allege that the counterclaim of the defendant is not found on pleadings of the She's the case of Obaniba versus Abibu, reported in 2021, 3 Nigerian Ukulolo Report, part 1762, page 84. In view of the foregoing, the objection of the claimants to the counterclaim fails and is hereby refused for lacking in merit. I shall now consider the merit of the counterclaim. It is clear from the reliefs being sought that being monetary claim, they are claim which actually pleaded and strictly proved. See the case of Southern Up Bottling Company versus Clifford. The defendants have argued that the claimant having not filed any defense to contradict or controvert the counterclaim are deemed to have admitted the counterclaim. The simple and short answer is that a reply to a counterclaim becomes necessary only if the counterclaim raises a fresh or new issue. In other words, where the issue relied on in the counterclaim are already covered by statement of defense. A reply is otiosi. See the case of Usman versus Garke, reported in 2003, 14 Nigerian Nuclear Report, part 840. See also Ovi Nigba Abibu, reported in 2021, Siri Nigerian Nuclear Report, part 1762. At 84. It is to be noted, the success or failure of the main claim does not derogate from the power of the court to determine counterclaim. The reason being that the two claims are treated as different in defendant's action, though being tried together. Where the principal claim fails, the law, however, where the principal claim fails, the law grants the court the unbridled license to assume jurisdiction over a living subsisting counterclaim. The converse reverse is also the case. See the case of MultiChoice Nigeria Limited versus MCSN Limited, GTE, reported in 2020, Nigerian Nuclear Report, 1742, page 415. However, it is to be noted that the success of a main claim may render useless a counterclaim in a suit. In this case, the claimant's success in this case renders the defendant's counterclaim nugatory. See the reason. The reason being that the evidence to be relied upon in proof of the counterclaim had been rejected by the court in the course of delivering judgment for the main claim. See the case of Mao Bison Interlinks Limited versus UTC Nigeria Limited. See also Odubao versus FSDH Sec Limited, reported in 2020, 8 Nigerian Nuclear Report, part 725, page 1. From the finding of the court as contained in the judgment, the claimant succeed in fact, while the defendants counterclaim failed in its entirety. And same is hereby dismissed. From all I have been saying above, and for avoidance and for avoidance of doubt, the order of the court is as follows. 1, the claimant is entitled to be settled by the defendants in line with Exhibit A. 2, the defendants are hereby ordered within 30 days from today, rent a shop for a period of 1 year, rent a shop for a period of 1 year, and pay the rent, and stock the said shop with goods for the claimant for having served the defendant for 5 years as per Exhibit A. The defendant's counterclaim fails for lacking in merit. Same is hereby dismissed. Cost is assessed at the sum of 500,000 naira payable to the claimant by the defendants. Judgment entered accordingly.
Please.
Lord, we're very grateful for the very sound and well-researched statement. We're most grateful. I'm sorry for coming.
Yes, thank you very much, Counsel, for your cooperation.
For the defendant, we sincerely must commend my Lord for the industry put into this judgment. We are grateful. Thank you very much.
It's all right. The soft copy of the judgment will be available on our website tomorrow, while the hard copy will be sent. Yes, thank you very much. The administrator, registrar, any other matter?
Yes, my lord. Mr. Lishi Yabanze.
Yes, thank you very much. Okay, call the case.
Yes, my lord. Suit number NICN ABJ 183-2019 between Mr. Lishi Yabanze and Femax British School. My lord, the parties are absent.
Are you sure the council have been served?
My lord,
because I have not received any formal notification concerning this matter.
My lord, council, we are here.
We are before my lord.
Yes, you have been served. Council
Yes,
in these matters, are they present?
Yes, my lord.
yes, my lord, they are
Okay.
present online.
Okay. Yes, what of the claimant? Is he present?
The parties are absent. Council.
Claimant, what is absent?
Yes,
My
my
lord,
lord.
the parties are absent.
Appearance?
Thank you, the honorable court. I am
Yes.
CEC.
Who?
CEC initials. CEC Njoku.
EEC in Joku.
CEC initials. C for
Okay.
Canada. E for England. C again for Canada.
In Joku.
Njoku is NJOKU.
Are you appearing for who?
For the claimant.
Yes, any other appearance?
Profound respect, my lord.
Yes.
I am Usman Gambo.
Usman Gambo.
Yes, my lord. My humble appearance is for the defendants.
Strictly the law, because it is
Was the defendants?
possible.
Yes, my lord.
Yes.
The matter is listed to play for adoption of final written address.
Okay.
Subject to the valid comments of the court, you are ready to go on, my lord.
Yes, you can go ahead.
Yes,
Have you
my lord.
filed
We
your
are,
addresses?
we are ready, my lord.
Have you filed the addresses?
Yes, my lord. We have filed our written address and the reply to his written address.
Okay. You can go ahead. Yes. Yes, Mr. Usman. Mr. Gambo.
Yes, my lord.
Yes, you can go ahead.
Yes, we have filed final written address, the defendant final written address on the 2nd day of December 2020.
2nd December 2020.
Yes, filed, dated the 19th November 2020.
Okay.
Yes, my lord.
Yes.
Equally, my lord, we filed our reply to the claimant's final address.
Yes.
My lord, is dated the 14th day of December 2020
Yes.
and filed on the 15th day of December 2020.
Yes.
My lord, we most humbly apply to adopt this as our argument, final argument before this honorable court.
Yes. Yes.
My lord, the purpose of adumbration.
Yes. Yes.
My lord, is a claim by the claimant for non-payment of salary.
Yes.
And damages.
Yes.
Yes, my lord, we have raised 5 issues for determination.
Yes.
In our written address.
Yes.
Yes, my lord.
Yes.
Number 1, my lord, is
yes,
whether this honorable court
yes,
can okay,
yes,
whether the termination of the claimant appointment was proper and in accordance with the conditions of service of the school.
yes,
Yes, my lord, this
yes,
the answer is in the affirmative, my lord.
yes,
Because the school handbook admitted in evidence by this honorable court is clear
yes,
that particularly in pages 13 and 14.
Yes, it says what?
The school reserve
what did page 13 and 14
an employee. Okay, my lord, the pages listed certain misconducts that will permit the school to outrightly dismiss the service of an employee.
Yes.
And to that effect, my lord, no notice or payment in lieu of notice is required.
Yes.
My lord, in the second issue raised,
Yes. Yes, yes.
Yes, my lord. Whether the employee was fully paid as as per interlocutory judgment entered before this honorable court. My lord, the claimant admitted, the defendant admitted part of the claimant's claim.
Yes.
And such was entered as judgment of the court.
Yes.
My lord, sorry to cut in. These are contained in his written address. Sorry, these are contained in his written. Let him adopt so that I can adopt and we'll proceed, my lord. The essence of adoption is to hit on those.
Mr. Gambo.
Yes, my lord.
Yes. Don't waste much of the time of the court. If your submissions are contained in your address, you don't need to read them again.
Rightly guided, my lord. My lord, the clear point that I want to make here is, my lord,
yes,
the claim of the claimant consists the payment also of tax and pension into his account, not to the relevant bodies.
Yes.
Which we vehemently disagree. And we urge the law, my lord, to hold as per the law provides.
As per the law provide, what did the law provide?
The law provides that every income in Nigeria is subject to tax payment.
Yes.
And the income of the claimant is not an exception.
Yes.
In addition to that, my lord, even though pension is an entitlement of an employee,
yes,
but it's not paid directly to the employee, but to the pension managers, my lord.
Yeah, but have you paid to the pension managers?
My lord, we are on the process. We are, in fact, we have reached a particular level of such payment, my lord.
Not you have reached. For how long will it take you? The law is very clear. When you employ somebody, the time within which you should open an account for him, if he did not open, you have a duty to open an account with pension administrators so as to pay his pension there. Have you done that?
They have not.
Yes. No, my lord. All accounts are provided by the employees. All accounts are provided by the employees, and they liaising with the managers for such payments.
It's all right.
Yes, my lord. In addition to that, and our final issue raised as issue number 5.
Yes. Yes.
Yes, my lord. It's whether the counterclaim not defended or opposed by the claimant should be granted. We urge, my lord, to consider this issue and resolve it in favor of the defendant, my lord.
It's all right.
My lord, there is counterclaim before this honorable court, and there is nowhere in the proceedings
address of counsel, my lord. They are non-new issues.
That this counterclaim was defended. As such, my lord, urge this honorable court to grant our counterclaim.
Yes.
Finally, my lord.
Yes.
We wish to adopt the final written address.
Yes.
And our reply to the defendant to the claimant's final written address.
Yes.
As our argument before this honorable.
Yes.
We urge, my lord, to grant our application.
Yes, Njoku.
My lord, we have our final written address, and it is dated and filed on the 7th day of December 2020.
Yes.
My lord, we have distilled 2 issues for determination by this honorable court.
Yes.
We adopt the arguments given as the arguments in support of our case,
Yes.
and we urge the Honorable Court to grant the release of the claimant as contained on the statement of facts.
Yes.
May it please the Honorable Court.
It's all right. This case is adjourned to 7th of October 2021 for judgment.
As the court pleases.
As the court pleases. We are most grateful, my lord.
You're welcome.